Hello friends and welcome again. In this particular video, we are going to continue our fundamental rights series, and in this video what we are going to do is that we are going to talk about Article 12 and Article 13 of Indian Constitution. So these particular articles are very important part of fundamental rights, and in order to understand the fundamental rights, it is necessary that we should understand about Article 12 and Article 13. So what basically Article 12 is? First, first we'll deal with Article 12. So Article 12 gives the definition of state. So in my previous video, we have learned that fundamental rights, what it actually does is that it puts some restraints on the state, okay, in order to give privileges to the individual. So it is necessary to understand what actually state is. So according to the Article 12 of the Indian Constitution, the following things include under the definition of state. So one thing more I would like to share, that kindly do not confuse with the term state, which is used to denote the territorial area. Okay, so it is far more bigger thing. That means, suppose for example, in India there is a state, for example Uttar Pradesh. Okay, so that very particular state, Uttar Pradesh, represents the territorial integrity of that state. Okay, it represents the population of that state, and it also represents the government of that state. Okay, so that state is different, but what we are going to deal with now, the definition of state, it actually comes under this state. Okay, it is the part of that state. So according to Article 12, the definition, under the definition of state, following things come. First is government and parliament of India. Okay, government and parliament of India. So we know that in India we have a bicameral legislature. One is Rajya Sabha, or the upper house, and also known as Council of States, and another one is Lok Sabha, or the lower house. Okay, House of People. Second is government and legislature of states. Government and legislature of states. As we have parliament in the case of whole India, we have legislature in the case of state, which is assigned with framing of laws. Third is all local authorities. Okay, local authorities like municipalities, panchayats, district boards, etc. Fourth is all other statutory and non-statutory authorities. All other statutory and non-statutory authorities. So statutory authorities are those authorities which are framed by law. Okay, by which are framed with the application of law. Those are called as statutory authority. And non-statutory authorities, we can say these are the executive authority, which is not framed under the law, but they're a kind of government agencies only. Okay, so under this, the examples like LIC, okay, that is Life Insurance Corporation, ONGC, Oil and Natural Gas Corporation, SAIL, that is the Steel Authority of India Limited, etc. So some PSUs or PSEs, we can say PSUs, that means the public sector undertakings and public sector enterprises, they come under this statutory and non-statutory authorities. Now, according to the Supreme Court of India, what Supreme Court of India has said, that private body or any agency working as an instrument of state falls within the meaning of state. That means if any private body is working under the state or as an agency of the state, they also come under the definition of Article 12. Okay, so this is all about Article 12, in which we have read about the definition of the state. Now we'll move on to Article 13. So Article 13 actually deals with laws that are inconsistent with fundamental rights. Inconsistent, or we can say in derogation with fundamental rights. So Article 13, it actually says that all the laws that are inconsistent or in derogation with fundamental rights, they automatically became null and void. Become null or void. Suppose if any law infringes the fundamental right or it becomes inconsistent with fundamental rights, that particular law automatically becomes null or void. So this is the first thing under Article 13. Next is the Supreme Court. So who is the authority which actually declares that such laws are inconsistent or in derogation with fundamental rights? So Supreme Court of India under Article 32 and High Courts of India under Article 226, they have the authority to declare any law null or void if they are inconsistent with the fundamental rights. So these are the authorities. So what is the term law actually? So it is also necessary to define that what are the laws, what laws we are actually talking about, what are their features. Okay, so laws here are permanent laws enacted by the parliament or state legislature. Okay, so permanent laws, they are the law making bodies enacted by parliament or state legislature. They come under the purview of law because that is their prime work to frame laws. Okay, next is temporary laws like ordinances. Okay, so we also read about ordinances when we'll read about the central and state governments, but just for now we can say that ordinance are the permanent, not permanent laws. They are temporary ones which are passed by the executive to meet any kind of emergency or unforeseen conditions during the time that the lawmaking bodies cannot function. Okay, so ordinance which are framed by the president of India, okay, or the governor of the state, these also comes under the definition of the law. Okay, statutory instrument, or we can say delegated legislation. So what are delegated legislations? So what actually these are? Actually these are the bylaws, government orders. Okay, so such kind of things are called as delegated legislation. So uh, laws which are framed by the parliament or the state legislature, ordinance which is framed by the president of India or the governor of the states, and the delegated legislations, they all come under the definition of law. Next point is okay, next point is that the under the article 13, it is very important point that the constitutional amendments which has been done by the parliament, constitutional amendments is not a law. So this was the idea. Okay, so this was the idea that the article 13 says that the constitutional amendments done by the parliament is not a law, but this very particular thing has been challenged in the Supreme Court, under the Keshwananda Bharati case. Very important, very famous case. You might have heard about this case, Keshwananda Bharati case in 1973, where the Supreme Court says that a constitutional amendment can be challenged. Okay, constitutional amendments. Okay, these amendments which are done by the parliament, constitutional amendments can be challenged on the grounds if they violate the fundamental law. Sorry, if they violate the fundamental rights, on the grounds if they violate the fundamental rights. Because, and so this is the one reason, if they challenge the constitutional amendments can be challenged on the grounds if they violate the fundamental rights, and judicial review is the basic feature of the Constitution of India. So we have also learned about the basic feature in one of my video. I have dealt about that topic, that judicial review is the basic feature of the Indian Constitution. That's why constitutional amendments can also be challenged. So this is all for this video, guys. I hope you like the video. It is a very I can say informative video for you guys, and if you have any kinds of doubt or suggestion, you can post it in the comment section. And if you have liked the video, do hit the like button and subscribe my channel. And there is a site www.rohansa.com. You can also visit this site. All the videos which I have made and uploaded on the YouTube is also available in this site. So thank you very much once again, and have an awesome day.